Mediation, arbitration, and litigation. Oh my. Hi, my name is Carl Burkhead. I'm an attorney with Wirth Law Office in Tulsa, Oklahoma. I've been practicing family and criminal law for almost 8 years now, actually almost exactly 8 years now. And I want to help you make law easy by just talking a little bit about the differences between mediation, arbitration, or litigation. So I know they all sound familiar. I know it's a lot of words that end in TION. Here's the difference. So litigation is what you see lawyers do on TV all the time. This is, when you see them up on stand going, "You can't handle the truth," or slamming their hands down, or "Objection, Your Honor," or whatever other crap you see in Law and Order. Trials don't exactly work like that all the time. There's not usually that much drama, involved. But litigation is exactly that. It's your attorney plus their attorney in court, going at it full on bumper car style in front of a judge or a jury and hoping that they win. Now, arbitration is kind of like that. The only difference is you're not in a courtroom. It's more like an office setting. There's not a jury. There is an arbitrator who is basically the judge. And there's not really it's not like a courtroom setting where you have people that can sit out in the audience and watch. It's all done a little bit more confidential style, but it is a lot similar to an actual litigated trial. You're still going to put on your witnesses. You're still going to present your evidence. There's usually still a court reporter in place. You're basically taking your case to an arbitrator instead of a judge and saying, "Hey, stand here in the place of the judge and just arbitrate this dispute for us. Figure out who's right, figure out who's wrong, give us a decision." Usually you need both sides to agree to arbitration. That's not something that the law requires you do it, especially in a family or criminal setting. I usually only see those more in business, civil litigation, contract disputes, or real estate, things like that. Now, mediation is different than either of those things in that mediation is the one place where you actually get to be in charge of whether or not you walk away with a resolution. Litigation or arbitration, you're showing up and you're basically saying, "Hey, we couldn't figure this out. We need you to figure this out for us." Mediation, though, is the stage where you're going to sit down with your attorney. They're going to sit down with their attorney. There's going to be an impartial mediator going back and forth between the two of you. And that's the time where you can figure it out yourself. I always encourage my clients, this is the time for you to really step up and try to take the reins and take charge of your case, because you're never going to have more power and more authority than you will at mediation. That's when you're the one that gets to choose when to settle, how to settle, what terms you'll accept, what terms you won't accept. So it's very, very important that you take it seriously when you get to that stage and make sure that you understand everything that's going on, make sure that you understand everything your lawyer is telling you, and ask questions if you are a little confused at all. If you have questions about these different types of legal work, definitely give me a call. I want to sit down with you. We'll go over the specifics of your case and figure out, maybe which dispute resolution option is going to work best for you. My name is Carl Burkhead. I'm with Wirth Law Office, and I want to help you make law easy. Thank you.